Good morning, everyone. Welcome to our my first summer meeting of the Environmental Control Board. Before we get down to any business, is there a motion to accept the minutes of the last meeting? The case appears to be unanimous, I think, and the minutes are accepted. We have today a large number of guests that we don't normally have, a lot of interns that want to get at some idea of some of the deep, dark intricacies of government that nobody else seems to care about. And judging from the number of hits we get on YouTube, not including ours, there's maybe a dozen people out there somewhere who are interested. They might be on the International Space Station because they're bored and have nothing else to do up there. We don't have a particularly large agenda, but I want to give an update to everyone here, which, and in particular, our interns may be interested in some of this stuff, as to things that have been going on and unearthed and so forth. This is my the glorious IRT again. I've been here for 7 months, and that process, I don't even have a lisp, but that's what this thing sounds like, and freaking me out. Things that I've looked at and compared to what original concepts were and how things have evolved over the last 35 years. So as part history lesson for our guests, the Environmental Control Board was conceived of in 1967 during the Lindsay administration as a super agency, which included the Sanitation Department, the Department of Environmental Protection, and about a half a dozen other agencies whose mission was, as articulated by the mayor's office at that time, to be a super environmental enforcement agency of the city of New York. And consistent with the philosophy of the time, that the city was too large to govern, everything was going to be governed by a committee. And this group would be the committee to deal with environmental issues, and there were a zillion other committees that were created. If you get the city's green book out, you'll find out that the city's populated with a zillion committees, most of whom people never heard of, rarely convene, and essentially do next to nothing, seriously. But some of them do. You know, this is one of them. One of them is CCRB, although they're, I could spend the next half hour just listing the flaws in many of these designs, including CCRBs. But the point being, over time, people kind of sort of like figured out that that system didn't work. The system was very similar to the system that existed in 1918 in Moscow, to how to run the city of Moscow, and they ultimately figured out it didn't work. This is right after the Russian Revolution. And when they figured out it didn't work, then they came up with the dictatorship of the proletariat, which lasted for another 90 years, and then they found out that didn't work. The point being is, since then, in the intervening 35 years, CCRB has been chopped up. The Sanitation Department is now the Sanitation Department again, Department of Environmental Protection is the Department of Environmental Protection again, Department of Health is the Department of Health again, et cetera, et cetera, et cetera. What we have left is the tribunal functions of CCRB. Although when you look at the charter, There is a lot of stuff in there that speaks in terms of enforcement and implies that this is an enforcement agency when it's not. I get directly from the 311 system every inquiry that's made, a complaint, letter, etc., about this agency and the rest of Oath. And invariably, somebody is moaning and groaning about ECB agents going out and doing whatever, issuing summonses, notices of violation, etc. I have met with a good portion of the members of the City Council. Virtually none of whom knew what Oath did or ECB did. I have met with community groups, citizen members, local citizens, etc. And uniformly, they equate the Environmental Control Board with essentially the Gestapo. There is an incredible cognitive disconnect between the perception of the Environmental Control Board by the people involved with the Environmental Control Board and with the adjudications unit of the Environmental Control Board and the public. They have the public in general has absolutely no clue as to what we do here, what our responsibilities are, and how we function. The terms that you hear are things like kangaroo court. You hear things like we're only interested in generating revenue for the City of New York. You hear things like totally incompetent operation because I got a summons that says I'm supposed to go to a hearing at 8:30 in the morning and I'm not, and I see hearing officers sitting around doing nothing and they don't get to me until 2 o'clock in the afternoon. It is rather disheartening to hear that sort of stuff. And part of the problem is really one of perception. People jump to conclusions based on incomplete information and incomplete perception of things. Something I hope to clean up. I'll give you an example. When someone goes to a hearing and they see either reps from within an agency or these business reps appearing to have familiarity with staff or hearing officers, or even going and using the same facilities and lunchroom facilities as our hearing officers, they're going to assume that they're in bed together, essentially. They're going to assume that the hearing officer from ECB and the inspector from whatever agency are colluding together to find them guilty of something. And let me take a sidestep over here for a second. The object of the exercise, when Oath was created initially by Ed Koch, and then was put on hold for about 30 years to a great extent, in 1978, was a recognition of that sort of perception. And his idea, and my marching orders from the current mayor are to execute that idea, is to make sure that the public understands that they have an unbiased, neutral forum where they can take their controversies with administrative agencies and get an unbiased, fair, and just resolution. And for those of us here who are attorneys, we understand that in our code of ethics, that even the appearance of an impropriety is just as serious and is treated just as severely as an actual impropriety. And appearances can be very misleading and people can be very cynical as a consequence. One of the reasons that the Taxi Tribunal was moved into orbit of oath, and the Health Tribunal and Environmental Control Board Tribunal, is to replicate what was very successful at oath in creating in everybody's consciousness that it is a neutral, independent tribunal where everybody gets an even break. I recall in 1978 when I was the advocate for the probation department, and for the benefit of interns, an agency advocate is somebody who is agency prosecutor for administrative discipline against the employees. 98% of disciplinary cases went through the grievance procedure under the contract, and very few went through the civil service procedure, which is under the civil service law, which would bring you to oath. That was year one. Today, it is the exact opposite. And the reason it's the exact opposite, when I talk to union presidents, it's because they believe that they get a fair break at oath, and that oath is not influenced by what the commissioner of a particular agency wants or doesn't want, as opposed to the grievance procedure, where ultimately it goes to an arbitrator, and the arbitrator is selected one by the city and one by the union. And historically what happens is they always make decisions 50% for the city and 50% for the union, and you don't know, people don't know what rhyme or reason why it falls one way or the other. I'm not knocking arbitrators, but if you don't make both sides happy, you don't get appointed an arbitrator again. And that's just plain reality on earth. In particular, with what the point I'm making is the Environmental Control Board Tribunal was moved in under oath's orbit about 5 years ago, something like that. With it as well, by the way, the other two agencies I mentioned, TLC and Health, a lot of legacy stuff was pulled in at the same time, stuff that is totally inappropriate for an adjudicatory body. I don't think every other city agency has quite gotten the memo that this is a neutral tribunal and that everybody stands the same. But by that I mean it doesn't matter whether you're an agency or you're a respondent or a complainant and a respondent, but some of them are civilian complainants, that is people from the public. As far as oath is concerned, they are all equal litigants. That is to say, the agency is a petitioner, and the person who got the summons or the charges and specifications is the respondent, and either the agency makes its case or the respondent makes their case, but they both walk in with equal standing. Nobody gets any special help, attention, or whatever, and you sink or swim. There has been some pushback, shall I say, from staff people who were moved over from other city agencies who seem to think that they have an obligation to resolve things on behalf of the other city agency, or provide services to the other city agency. We're not DCAS. We're not the city's Department of Administrative Services that provides paper clips or paper or services to other city agencies. We are not providing services to city agencies. We are providing a tribunal, an administrative tribunal to the city of New York. In 1940, administrative agencies like we know them today that basically run the government didn't exist. That started with the New Deal. There's another piece of history lesson here. Since then, virtually every citizen's contact in this country with anything relating to government has to go through some kind of administrative agency, whether it's as basic as DMV or getting a parking ticket. That's it. Very few people wind up in serious court. Very few people will really wind up in criminal court or state Supreme Court in a lawsuit or something like that. And their view of what government is, it depends on their contact with that administrative agency or that tribunal. And we're the tribunal for the city of New York. And if you're standing online for 3 hours at DMV to get your driver's license renewed, you're not going to walk away with a very nice opinion of the state of New York. And if you come in at 8:30 in the morning because an agency gave you a summons that said was returnable at 8:30 in the morning, and that agency doesn't supply enough personnel to prosecute the summonses they issued at 8:30 in the morning, and they're standing around, they have hearing officers standing around not doing cases because the cases aren't going through, there's a bottleneck, and I get my summons heard at 2 o'clock in the afternoon, I'm going to think the Environmental Control Board is run by a bunch of clowns and incompetents. And what's more, I'm going to think that the Environmental Control Board issued the summons to begin with. So that's not very cool, and that's going to stop, among other things. It's going to be very difficult to disabuse a lot of the city council as to what this group is about, what we're about, what we do. We have a very good reputation on the historical side, on the outside. My conversation with Bill de Blasio last October, which lasted about 5 minutes when he offered me this position, essentially said that what he wants is every citizen of the city of New York, every inhabitant of the city of New York to believe that when they have a hearing, that it is fair, neutral, and impartial. Period. That's my marching orders, and that's what we're going to accomplish one way or another. And that is involving right now a lot of new rulemaking going on, a lot of procedural stuff going on, teasing apart things that do not belong in an adjudication environment. Things like revenue collection. If you're an impartial tribunal, you have to be totally disinterested as to whether or not there's any revenue at the end of the tunnel. That is the Department of Finance's problem, not ours. We will not be chasing people to pay their fines. If we adjudicate somebody owes the city of New York money, that is an issue for the city of New York. Just like if you get sued in civil court and there's a judgment against you, it's not the court that chases you around to make sure that you pay. The plaintiff or whomever gets the judgment is the one who has to go to the sheriff or the marshals or go to the bank and put a lien on your, or levy on your property. It's not the court that does that, because that makes the court look biased and partial. If there is, if somebody screws up at a proceeding, you can always hit the reset button, but nobody's going to be cut slack one way or the other. It's going to be very, very neutral. We've already had some issues at some of our facilities where representatives from certain agencies were upset that they couldn't use our bathrooms or our lunch area because the public sees them, you know, hanging out, attorneys for, actually none of the agencies here, so what I'm talking about. They see somebody from that agency, a prosecutor from that agency, hanging out in the lunchroom with the hearing officers. Oh yeah, right, I'm getting a fair deal. And they may be getting a fair deal, but that's not the perception. And like I said before, the perception is just as bad as, in fact, that's what's really happening. And like I said before, the guys in this room who are attorneys are very sensitive to that, because if we're not, we can get disbarred, among other things, which is not very nice. So that's what I have been finding in the last 7 months. And what I've been involved in the last 7 months is working with the Mayor's Office of Operations as our resource to come up with new and better designs to functionally work these things through. The most public one will be very soon when we start printing new summonses. One of the weird things that I found out is that we actually print the summonses for everybody, rather than each agency printing its own. Which I found kind of weird. If you've ever been to one of the basements of police headquarters, they got a print shop down there that makes the New York Times jealous. Starting very soon, summonses will say across the top what agency is issuing the summons, instead of just a code number. People are not going to think that the Environmental Control Board issued them a summons for recycling. They're going to know it's the Sanitation Department or the Department of Environmental Protection or whatever. They're going to know that the summons came from the Health Department. It's going to be very, very clear that summons came from the Tax and Limousine Commission, not from Oath. And that Oath is not the Tax and Limousine Commission. Actually, that's a weird scenario where it's the exact opposite of what I'm talking about. You go to Long Island City, where most of the taxi tribunals are, you talk to the drivers, they think they're at TLC. They don't think they're at Oath. A lot of it is because of the legacy stuff that was brought over, and it's got all the trappings of TLC there. That messes up the whole view of what administrative adjudication is. And I don't want 10 years from now, while I'm sitting on the beach in Tahiti, hopefully, to read that there's a Justice Department study that was done in New York City, akin to the one that was done in Ferguson, Missouri, where they concluded that their administrative cases were basically just a farce to generate money. Ain't gonna happen, at least not if I'm here. So that's essentially very broadly, without getting into the details, and I'll be happy to go into the details with anybody who wants to, what our future plans and like that are. But that's where we came from, where we're at, and I hope I didn't describing where we're going. And we'll see if it works. So, that said, now we get to the fun part of the meeting, the business part. But once you get paid all this money for, at least the citizen members. I'm being facetious. They don't get paid anything, really. I'm saying that for the benefit of the patrons. We have a presentation on our final rulemaking.
Elaine Balsam, Deputy General Counsel for Oath. Good morning, everybody.
Good morning.
We have two final rules today. The first one is additions to the Department of Sanitation penalty schedule for violations pertaining to the recovery of refrigerants. The law department held a public hearing. The law department cleared it. Any questions on that one? Okay. Vote on them together or separately?
Unless anybody's got any controversy or questions on any particular one, I guess we can do them all together.
Okay. And then the second final rule pertains to ECB's procedural rules. We made two changes. The first allows for personal service of decisions and orders on somebody if they don't want to get it in the mail. And the second changes the service for cease and desist orders from certified mail return receipt requested to regular mail. Any questions on that? Yeah.
I just wondered if we have a chance to review National Grid's response, inquiry, I guess their comments on this.
Yes. I think National Grid's idea is a great idea. I want to set up a way that we can get an email address. Obviously, getting an email address from big respondents like National Grid is going to be easy because you're going to have a set thing. But I want to have a mechanism whereby basically anybody can register an email address with Oath for receipt of service, similar to what is in place in federal court. If federal court, I'm admitted to federal court, and the Eastern District and the Southern District have my email address. If anything is filed in either the Eastern District or the Southern District that relates to me, I get an email immediately with a copy of whatever was filed, which I think is a neat, it's a terrific idea. It's going to be something else for me to give our IT people a headache with. You know, the snail mail is becoming history. I very much like the National Grid's idea.
Would that require any amendment will that require any changes to the rule to be able to do that?
It might, but before we make those changes in the rules, I want to find out what the technical hoops have to be. You know, I don't want to tell them. My concern is that we don't wind up with a bunch of stale email addresses. Because I know National Grid is going to always be National Grid, but John Doe or whatever, you know, this year may have an AOL address, next time they may have a Gmail address, and one dies and they never look at it, that kind of thing.
Because there's certain, I agree with you, but I'm saying that for the agencies in particular, and of course, as National Grid points out, to their benefit also, this is a great idea in terms of cutting back on costs and actually delivering decisions by the push of a button. It goes directly to an agency email, similar to how we do it right now. We get decisions from the appeal board. So, you know, this is really good. I think if we were to try to accommodate that rule or otherwise.
Yeah, the great part of it is it winds up on the desk of somebody who can do something with it right away, rather than bouncing around bureaucracy for 2 months before somebody says, oh, we were supposed to do that 30 days ago. And lovely.
Any other questions, comments? That's it. Oh,
Is that it?
yeah, just the two.
Is there a motion on either of these, or both of these together? I think it's unanimous. I vote two. I think DEP has a request.
Morning, Russell Pecunis, Assistant Counsel, DEP. This month, DEP has requests for cease and desist orders, the usual monthly batch of 28 requests for failure to comply with orders to install backflow prevention devices, and also 18 requests for cease and desist orders relating to expired certificates of operation for boilers that are using number 6 oil. The statute, the new law banning the use of number 6 takes effect on Tuesday, the 30th. We have something on the order of about 100 buildings right now at various stages in the cease and desist process coming into compliance. So far, the issuance of the orders has been very effective in terms of getting sort of the laggards and the people who inevitably, whenever anything like this happens, always wait until the last minute to do it. It's been very effective so far. Since we do have people whose certificates are valid through June, we will have sort of a continuing trickle of these in the second half of the year, because we have to issue a violation first and get that adjudicated before we can bring the request for the cease and desist order. But so far the program has been going very well and has been very effective. So the DEP is requesting that the board approve the 18 boiler-related requests as well as the 28 backflow-related requests.
Any questions? Is there a motion? It's unanimous with one abstention.
Thank you.
That was short and sweet. Now this is where we get serious.
Good morning, I'm Kelly Corso, Assistant Director of Education for ECB, and I'm going to talk about the pre-sealing reports. We have 19 pre-sealing reports today, and it's very exciting. We have one post-sealing report to talk about. 10 of the pre-sealing reports pertain to backflow violations. In all of those cases, the hearing officers recommended that there be no sealing or other action because the respondents were able to show at the hearings that the approved backflow devices have been installed and tested at the premises. The remaining pre-sealing reports pertain to 1 noise code violation and 8 air code violations. The noise code case, in this case, the DEP representative requested that the proceeding be discontinued because a recent inspection of the premises showed that the respondent had moved out of the cited premises and the equipment had been removed. The hearing officer agreed with that recommendation, and the hearing officer recommended that the proceeding be discontinued. Moving on to the air code cases, there are 8 of these, and 4 of those cases, the respondent's representatives did provide proof that they had obtained valid operating certificates for the boilers and burners that had been cited, and they had come into compliance with air code. Based on that evidence of compliance, the hearing officers in all 4 cases recommended that no further action be taken given the compliance of the respondents. In the 3 remaining air code cases, DEP DEP requested that the C&D proceedings be discontinued because the respondents had obtained valid operating certificates for alternative fuel sources, bringing their boilers and burners into compliance with the air code. And the hearing officers in all three of those cases agreed with that recommendation and recommended that the C&D proceedings be discontinued. In the last air code case, this would involve a spray booth. DEP requested that the hearing, that the C&D proceeding be discontinued, and that is because the respondent had moved from the site premises, and the site premises is now vacant. And the hearing officer agreed with DEP's recommendation that the C&D proceeding against the respondent be discontinued. So that is the summary of the 19 pre-sealing reports. I'm not sure if you want to deal with them first and then the post-sealing report, or everything else together.
Well, let's do those first. Is there any question on any of those? Is there a motion on any of those? And it's unanimous.
Okay. The post-sealing report pertains to a noise code violation that occurred at a restaurant in Manhattan. It dates back to 2013. It involves TJ Food Corporation, and they had an air conditioner at the restaurant, which was exceeding the 42 decibels that's required by the air code, and they received a violation from DEP. In July of 2013, they entered into a stipulation, and in September of 2014, it was revealed that a DEP inspection was showing that the respondent had not complied with the air code. So a C&D order was approved by the board in October of 2014. At the pre-sealing hearing in November of 2014, the hearing officer recommended that based on the evidence that the respondent was able to show that they had come into compliance, that DEP re-inspect the equipment, and the equipment remain unsealed. If the initial re-inspection showed that there was no further violations. And the board adopted the hearing officer's recommendation. Subsequent to that, in May of 2015, DEP re-inspected the equipment and found that the equipment was exceeding the noise code's allowable decibels, and they sealed the equipment. The respondent quickly replaced the equipment in May, and they appeared at a post-sealing hearing to request that the equipment remain unsealed. Subsequent to that, DEP inspected that equipment and found that the new equipment was in compliance and recommended that there be no further action given the respondent's compliance, and the hearing officer agreed with that recommendation. So the recommendation is that the equipment remains.
Isn't it absolutely amazing how they complied the moment we sealed it after all those years? That's an editorial comment, guys. Is there a motion to accept? It's unanimous. Thank you. Now, we're going to go into executive session, which, for the benefit of the interns, etc., who may not be aware of it, whenever an administrative agency goes that has a board or a public hearing type situation, into executive session, and we'll resume in a few minutes.
With respect to the full board's review of the appeal in New York City versus INL Contractor Service, alternative 1 before the board remains as was provided. Alternative 2 has been revised as follows. The final 3 paragraphs are revised to read: respondent's representative did not move to dismiss the NOV from proper section of law. Respondent's representative showed no confusion over the section of law charged. The hearing officer read the correct section of law into the record. Section 3-33B of 48 RCNY allows amendment of an NOV at any time to conform to the evidence. The board is persuaded that respondent was not prejudiced or unfairly surprised by the omission of the period between the last 2 digits of the section of law as written by the IO. Consequently, the board hereby amends the NOV to cite BC 3304.3.1 as a section of law charged. Accordingly, the board reverses the hearing officer's recommended decision in order, sustains the amended charge of BC 3304.3.1, and imposes a civil penalty of $1,200.
Is there a motion to accept that version? That is 8 in favor, 1 abstention, and 1 voting against. And there's another set, right? You didn't forget the,
We have before the board the recommendations of the June 4th and June 18th appeals panels as provided. Is there a motion to accept those recommendations?
Tom, just if you could.
Yes.
There were 2 cases that I had to recuse myself
Right.
from that panel.
I should mention that on the June 4th panel, where Dan Albano was the agency member, 2 decisions, 2 appeals rather involving vendors were decided by a panel that included Ronaldo Hilton as the agency member in place of Lieutenant Albano.
thank you. Is there a motion to accept? It's unanimous.
Thank you.
I think that wraps up today's fun meeting. And I thank you. Is there a motion to adjourn? We are adjourned.